I want to say that was a remarkable panel. It really was. I think we all go to a lot of conferences, but that panel was incredibly moving, and I want to thank Vera and all the speakers for really shining a light on some of these issues. It's a pleasure for me to speak with you this morning at this very important convening. I want to thank the Vera Institute, its president, Nick Turner, whose vision and remarkable leadership of Vera has really helped bring a whole new light onto some of these very important and pressing criminal justice issues today. I want to thank Fred Patrick as well and the Vera staff for the very important work that Vera is doing on these issues in correction, sentencing, and in particular on the issue of solitary confinement. And for bringing us all here today, because this really is an incredibly important moment. As somebody who has spent her whole adult life engaged on issues of criminal justice reform and who has represented individuals who have been subject to prolonged isolation, I can say that 10, maybe even 5 years ago, there were too few in this country who were concerned about what was happening in our criminal justice system, or were looking at how we as a society were using restrictive housing or solitary confinement. And so I am particularly honored to be here this morning among federal partners who are real visionaries, among corrections leaders, experts, and advocates, as we take part in an event which to me does truly reflect the tectonic shift which was referenced on this panel. Congress, just in the last couple of years, has held 2 hearings on this issue in 2012 and 2014. And in the first ever hearing on the topic, as Carrie mentioned, in 2012, senators heard compelling, indeed searing testimony from Anthony Graves, a man who was wrongfully convicted and had spent 16 out of 18 years in prison in solitary before being released by the courts. And he talked about how psychologically damaging his isolation had been and its impact on his family. And I think we heard the very moving testimony from Shaka Senghor just now, who makes clear the case for a human dignity approach. As Nick Turner noted, this past year, Supreme Court Justice Anthony Kennedy also shined a spotlight on solitary confinement, telling a House Appropriations Subcommittee in March that solitary confinement literally drives men mad. And in his view, he said the idea of total incarceration just isn't working, and it's not humane. In a written court opinion in June, Justice Kennedy expressed deep reservations about prolonged isolation in a cell that he described as no larger than a typical parking spot 23 hours a day. He saw a growing public awareness on solitary confinement, but observed that scientific research in the Supreme Court had long made clear its dangers. And he cautioned, years on end of near total isolation exact a terrible price. As has already been mentioned, President Obama himself put a spotlight on this issue in his speech in July at the NAACP, and he pointed out solitary's potential harm to reentry and public safety, saying it's not going to make us safer. If those individuals are ultimately released, how are they ever going to adapt? It's not smart. I think importantly, state officials have been engaged in the hard work of pursuing alternatives. And in fact, some of the most thoughtful, courageous, and visionary leaders on reforming solitary confinement practices are state corrections officials, people who know day in and day out the very difficult work, the dangerous work sometimes, the very real challenges of jail and prison management. And we are honored and lucky to have a few of them among us and to have just heard from Rick Ramish himself. But it's not just government officials that are driving this conversation. Researchers like those at Vera and several of you in this room today are really studying the impact of solitary confinement practices and exploring safe alternatives. And the reality is, as we just heard, is there is too little data, and we need more of it to truly understand the scope and depth of these issues and dynamics. The media has done incredibly important work as well in lifting up and showing us where reforms may be most necessary, but also helping us confront its complexity. So the New Yorker's reporting on the tragic story of Khalif Breder, who's been mentioned several times this morning, NPR's sustained coverage, Carrie Johnson and others at NPR, the Marshall Project's coverage of states' attempts to scale back their use, the use of solitary. Reporters really are helping us understand where reform is needed most. But I think most importantly, the public is really engaged. And as part of the broader conversation that is happening right now about the fairness of our criminal justice system, people on both sides of the political aisle, people in corrections and outside, are actually talking about conditions in our prisons and jails and whether there are safe alternatives to solitary confinement. At the Civil Rights Division, we have worked for over 20 years to stop the excessive use of solitary confinement in state and local jails, prisons, and juvenile facilities. This work has gone back as far as 1993, when the division obtained remedies to correct the overly restrictive and anti-therapeutic 23-hour per day lockdown of adult prisoners with mental illness in the Montana State Prison. More recently, we focused on the special harm caused by solitary confinement on vulnerable populations, such as prisoners with serious mental illness and juvenile detainees. For example, in 2013, we found that a Pennsylvania state prison used SCI Crescent used long-term and extreme forms of solitary confinement on prisoners with serious mental illness and or intellectual disabilities in violation of the Eighth Amendment. Based on our findings there in that case, we actually expanded our investigation statewide. And in 2014, we found that throughout the state, prisoners with serious mental illness were subjected to prolonged solitary confinement under harsh conditions, causing serious harm. Our experts found that those conditions led to severe mental deterioration, psychosis, and acts of self-harm. And specifically, more than 70% of documented suicide attempts over a 17-month period occurred in the state system's solitary confinement units. And there's been tremendous leadership on the part of the corrections leaders in Pennsylvania to address these issues. Ohio, we focused our recent efforts on restricting the use of solitary confinement on youth, on juveniles. Our statewide juvenile case in Ohio last year led to a landmark agreement that eliminated disciplinary isolation for youth with mental illness, greatly reduced cool-down isolation, and ensured that youth received individualized mental health treatment. And the goal of the treatment is to prevent and address the violent behaviors that typically land youth in solitary. This summer, in what has now been covered fairly well, but we in the U.S. Attorney's Office for the Southern District of New York reached an agreement to address a variety of deeply entrenched unconstitutional conduct at Rikers Island, including the abusive use of solitary confinement. And the investigation found that adolescent inmates, many of whom have mental illnesses, were routinely placed in solitary confinement for weeks and sometimes months at a time. On any given day in 2013, 15 to 25% of the adolescent population was in punitive segregation, often for nonviolent infractions. Under the agreement, which has been preliminarily approved by the court, punitive isolation now is prohibited for inmates under 18 years old. New York has decided to eliminate the practice for inmates up to 21 years old, too, by the start of next year, so long as the jail gets the resources for adequate staffing and programming. And last year, we filed a statement of interest with the Department of Education in a class action involving the Contra Costa Juvenile Hall in California. Following our filing, the state agreed to stop using solitary for disciplinary reasons and to limit its use as a response to immediate safety threats to a maximum of 4 hours. That's an overview of the enforcement work that we are doing. We just recently opened a new case in Birmingham, Alabama as well, looking at juvenile solitary confinement there. But I want to emphasize that our work is only one of several DOJ components and interventions on this issue. We have conscientious partners in the department, including Carol Mason and Denise O'Donnell and others at the Office of Justice Programs, Charles Samuels and other dedicated professionals at the Bureau of Prisons, and our partners in the Civil Division and the U.S. Attorney's offices around the country. And we are all very engaged in the kinds of topics that are being discussed here today. We work collaboratively, but we are also counting on the advocates and experts that are in this room and on the corrections officials in this room to help us find challenging solutions to these very difficult and complex problems, including, of course, identifying the available and best alternatives to solitary confinement. And so I thank you all for coming here this morning. I thank Vera for hosting this really important discussion, and I look forward to learning together and over the rest of this morning into advancing a human dignity approach in the months and years to come. Thank you.